Testing 1 2. Testing 1 2. Testing 1 2. Testing 1 2. Oh, those are clean. I like that. Alrighty. What's up, everybody? I'm your host, Supreme Decisions, and today, as you see in the title, we're going to talk about trust. Not that you trust me, but trust to protect your personal and business assets. Now, trust under fire, how to bulletproof your estate against legal challenges. Now, this is one of the things that I've actually taken a greater interest in, especially talking about, because I've watched in the last probably 90 days. Like, it hasn't been like a very long period. But I actually set up a channel, I want to say a few years ago, where I was going to do Supreme Trust, where I'm just going to be talking about trust, how to build them, how to create them, and how to enforce them, because that is the biggest part of the trust itself. And I've actually gone through and I've looked at several that people have created on their own. They've had others that were doing them and never fully understood the context of the how and the when and the why of a trust. In today's episode, I want you to think about something right now. When you leave this world, are you leaving behind order or are you leaving behind chaos? And that's why I talk about in the last 90 days, because I've lost a couple family members, I've lost a couple friends, and I've watched how one who did it right is just pretty much just navigating easy, because you're in a time of turmoil and you're the ones that's left pretty much holding the bag. And in the midst of holding that, you're still grieving. So you want the greatest amount of peace of mind, for one, and then two, you also want the greatest amount of protection. And those can be done in a matter of just putting the right verbiage together. And the reality is, every trust tells a story about wealth, property, family, and intent. But if your trust is poorly written, vague, or improperly executed, it doesn't tell your story and it becomes a battlefield. Because this is what I'm seeing the most often now. It's poorly written. It's vague. The language is not proper. And lastly, if you're doing it on your own, in 9 out of 10 cases, it's not even executed properly. And then lastly, I'm actually add in one that I didn't write down here. It's not properly funded. And if it's not funded, it's not in effect. And courts across the country, both state and federal, are littered with families tearing each other apart because the trust failed to protect what it was designed to protect. And even in the context of this, it's understanding taking your personal assets and liabilities and placing them somewhere else. So you then protect your personal assets and relieve yourself of those liabilities. Now, today we're going to cover 4 things, and we're going to touch on them. We're not going to go crazy in depth with them, but we're really going to hit some real things, and they're going to be tangible. Now, why create a trust in the first place? And why is it often the most powerful estate tool? Say that one more time. Why do you create it in the first place? And then the creation of it, why is it your most powerful estate tool? Because a will isn't enough. Because it doesn't take you away from tax liability. the videos aren't enough. The putting a business together isn't enough. So why is it the most powerful estate planning tool? 2, the disasters that happen when a trust is drafted poorly, sloppily, or executed incorrectly. This is generally when you're attempting to place property into a trust and it's not executed properly. Or whenever you're looking with bank accounts, something as simple as that, or even future revenue streams. Because this is one of the things I had to set up for my family, because I do have extra businesses which my family, once I leave here, need access to. Now, my plan isn't to leave a whole bunch of debt, but at the same time, they're going to still need assets that's going to be recurring that they can utilize. Now, most common legal challenges brought against trust, because most people have no idea what challenges may occur from a trust, because you're reading it or you're seeing something and then they say, all right, it's written, fill out this piece of paper. They give you a piece of paper, say, all right, now go do this and you're good. They don't tell you what to expect. And that's one of the things that, again, separate me from everyone else, because I deal with expectation management, so you can know the possibilities. Not that they are, but that you can prepare for them if they do ever show up. 1 is undue influence. What is that and why is that? How can you defend against that? The lack of capacity. Again, things that we're going to talk about. Fraud. Improper execution. These are the most common legal actions that you're going to deal with or come up against with a trust. And I always tell people, do not have someone write your trust that does not know how to defend it, because that is the most important and most critical action. They must know how to defend what they are writing. So, finally, the arsenal of defenses. How to bulletproof your trust so it stands even under the heaviest legal fire. So that'll be someone like myself taking shots at you because your trust is poorly written, not executed properly, or you don't know how to defend it. Because it's one of those tools that I tell everybody, you have all the pieces to the game. You have no idea how those pieces work, nor how to maximize those pieces when they're in your possession. And this is when I tell you it becomes high-level chess. Because the game, it's easier, because I actually had a client that I spoke with on yesterday, and it was one of the greatest things that ever could be. I had a conversation with him 6 months ago, and to yesterday or the day before, something I said 6 months ago popped up. He goes, and you answered it quickly. I said, because I was prepared for it. I saw the move they were going to make. I saw it already. So we don't have to keep going back and, well, I've played this game 100,000 times. I know what their move is going to be. When they move a certain place, I know where they're going, because I've seen it before. I don't play law, but I play this at a high level. This is my game. This is what I do. So understand this, because along the way, I'm going to bring you Supreme Court precedents like Hotto v. Irving, where the court recognized the constitutional dimension of property rights, and I'll show you how state probate codes, federal framework under ERISA, E-R-I-S-A, and tax law intersect with trust law. Because most people have no idea what trust law entails, and most people definitely have no idea how the tax code works. And guess what? Appreciate you, Fort Valley State, and well, I don't know. I think it's Perimeter College now, because it was at one point DeKalb College, where I started, and I majored in accounting. Didn't finish though. We're not gonna go deep in that. Didn't finish. I started, didn't finish. So we're gonna come in. Well, I don't see your degree, because I don't have one. Anyway, This episode is not just about creative lawyering. It's for everyone who has assets, family, or even just a peace of mind to protect. By the time we're done, you'll understand how to create a fortress, not a house of cards. And here's the misconception or the misnomer in this. Most people, when you hear trust, you think of wealthy. Just like when I was speaking about a certain contract, you heard about it from the elites. And my brother's like, no, you need one. And then I thought about the Dave Chappelle skit. This brother had nothing and she took half of that. You don't have to be uber wealthy or even wealthy. Because if you have just enough to get by, you need to trust. Because if you don't have a trust, the little bit you have that you're saving, that you're struggling to fight with, can be taken. I'm going to say that one more time. If you don't have to be uber wealthy to have a trust. You can get a trust if you are working to do anything. If you're trying to stabilize your life and use something to protect your assets that you're gaining, trying to get, or having an inclination of getting. A trust is something for you. You don't have to be the uber wealthy. You just have to be wanting to save and protect yourself. Now, the reasons you create a trust. Here's the easy. Avoid probate. Because taxes on probate is, I believe, is at 52%. It may go down, it may go up, but it's still half. Whatever it is that's taxable is at 52%. Now, you may want to go back because each area, each state, each asset has different variations. So again, but you're still under attack for what is out there, and it's high. Now, when you avoid probate, probate is public, costly, and slow. Trust keeps matters private. And that's the greatest way that you want to. You don't want everybody all in your business. You don't want a whole bunch of attackers that just because. This is one of those things that the trust does. It protects your private life. Notice I didn't say anything about wealthy. If you want your life to be private and your assets to be protected, that's what you want to trust for. Now, you control distribution. With the trust, you dedicate how, when, and under what condition assets are distributed. Spendthrift provisions and staggered distributions are the best outlays. Why? Because when you put a cap on how much someone can use out of the trust, or when they can be distributed. Give you an example. If you watched Power was one of my favorite shows. When Ghost had died, one of the things his trust stipulated was everything goes to Tariq. However, nothing gets distributed until Tariq graduates college. And he has to maintain a certain grade point average. If not, the money goes somewhere else. Now, this is one of those. He put stipulations on it or conditions, and he put staggered distribution. But the distribution was then named through the executor, who would never become executor until he met the conditions of the trust. Now, if let's say he never graduates college, he has a 3.9 or a 3.2 instead of a 3.8. The next person in line would be his younger sister, because he had divorced Tasha prior to. But again, it still has provisions and conditions and also distribution outliers. And these are the things that the trust is set up for. And here's one thing, because give you an example too. I had money put up on my passing. there's a staggered distribution to each one of my children. Don't have any requirements. However, I also have a provision for each one of my children. If they don't meet that provision, they lose their money. That money goes to it. Let's say, give you an example. It's kind of staggered because I have a plethora of children. So let's say we got the oldest, and then we got the youngest. Oldest has already met all the provisions. Oldest girl, oldest boy, they've already met the provisions. So now I've got other children under them and one baby. Well, he's not a baby, he's 15 years old. Anyway, 3 of them are pretty much in line for what they're supposed to do. So let's say one falls out the trust for whatever reason. Now, the 3 that have met the provision, their share now increases because one is out. So now the distribution is still staggered, but it increases in either payment or time, and they get to choose which is which. Why? Because if you have an opportunity to have payments for 12 months versus 24 months, what are you going to take? Or if you have more money in a shorter period of time, which one are you going to take? Because again, I look at it this way. If you're not on your feet, let's say they use it just to get on their feet, whatever it is. If you're not on your feet in 12 months, you're not going to get on your feet. You're not trying to be on your feet. Because again, my job is to aid you to get to the next level. It's not to put you at the next level. Just like I even told my youngest son, your uncle is not here to take care of you. Your uncle is going to provide you for a job when you turn a certain age. Your uncle is going to open doors for you. That's all his job is. It is up to you to stay in those rooms. But if you fuck off and don't do what you're supposed to do, your uncle is not obligated to take care of you. That is your job. And he has been instructed. Once he opens the door and that door closes, if you screwed it up, it's on you. He's just there as a resource for you. And if you mess up the resource, it is you, not him. It is not his responsibility to make sure your life is better. It is only his responsibility to offer you opportunities. That's it. And this is where the control and distribution comes in, the planning, because again, someone else is not there. I'm not trying to create a dependent. I'm trying to make sure that they have an opportunity. And that is the whole point of my trust. You can set yours up however you like. And again, not wealthy, but I have assets in which I want protected, and I need a means to make sure it's distributed properly to the people that I love without issue. Always understand that. Now, tax planning. Federal estate taxes exempts under IRC 2001 through 2010. Trust can reduce exposure to taxes. I literally just said that. When you avoid probate, there's a probate tax. To avoid probate, you are a part of those exemptions by having a trust. Now, because that exposure can be costly, because again, not costly on you, you're dead. But it's costly on those that are behind you. And it's one of those things, too, that I can appreciate with my father. He wasn't a wealthy man, but he was smart enough to understand he needed the trust to make sure we had assets when he passed. That's the whole point of it. Making sure the assets are protected and that it gets to the people it's supposed to. Now, asset protection. You're shielded from creditors if structured properly, i.e., an irrevocable trust. If it is structured properly, I'm going to say that one more time. Structured properly, you are shielded from creditors. And that's one of the biggest things for it. It is not set up properly. The execution is poor or it's written poorly. This is why you go to someone who understands how to defend it. That's what's important. Now, the asset protection, again, out of your personal and creates a whole nother entity that shields you from taxes. It gives you control over who gets what, when, how, and hell, for the why. And it also protects you from someone else garnishing or taxing those after you. Now, special needs and federal law. Special needs trusts protect, benefits eligible under 42 USC 1394P. Say that one more time because a lot of people are going to get confused by it. Special needs or special needs trusts protect benefits eligible under 42 USC 1396P. The reason being is because every trust does not have to look the same. Because you can have an irrevocable trust. You can have a simple trust. You can have a complex trust. You can have a complex irrevocable trust. You can have the special needs trust because it's doing a particular job because you're the controlling the dynamic of it. You are setting this up. If you're one of those people that need control, this is the way you do it. You do it through a trust because you also make sure you are protecting those you love. Now, again, the case example. Howdo v. Irvin shows constitutional protection of property interests. The court struck down government attempts to eschattle small land interests, underscoring why private trust planning is key. Basically, they stopped the government from taking land just because the person had passed. Because even the small land interests of someone, no matter how minute, even if it wasn't directly to them, it shows to underscore why private trusts are key because it stopped the government from taking something just because someone had passed. It gave it to someone else without issue. This is the whole point of it because you are controlling who takes your property after you. And this is probably it's the most thing, I don't even understand how I would even word this because I watched people, I'm gonna give you a story. I was selling insurance, and I think I gave this story once before. I was selling insurance. And I would post, this is what I do. And most of the people that I worked with were Dublin, Georgia, Savannah, Georgia, Hinesville. I was deep South Georgia, Reedsville, right outside the prison. I was everywhere else but my hometown. So one day, one of my partners, he posts his dad had passed away. I think this was the last time I ever said my condolences. I actually do believe that's the last time I ever said it because I don't say it now at all. And it's like, it irks me to even think about it. But I typed in on Facebook, my condolences. This bastard lit into me. And I mean it the way I said it because he's still my boy. I still got love for him. But this bastard lit into me and he goes, how could you not have been here to help my father? And I was like, what do you mean? I showed you every week. You have my actual phone number, not the office number. You have my personal phone number. But then I thought about it. Why did I not go directly to my friends and say, hey, let me do this? And then my wife at the time and fiance now, she actually brought up something that was the most beautiful thing in the world. She goes, why are you chasing someone to protect themselves? If I have to convince you this is what you need, You're the problem. So when everything is lost, it was a choice that you made to lose it. Now, why is that the asshole response? Because it's the true response. You have control to protect yourself. If you choose not to do it, it's on you. These are the things, but again, it's doing it and absolutely irrevocable and revocable. I appreciate that, Twin. I actually didn't say it that way, but I appreciate that. Because, Twin, you're always in here. I appreciate you. But it's understanding that even a drowning man must participate in his own survival. I've adapted that a long time ago because I'm not going to chase you to free you. Because like I said, my trust is written. My assets are protected. My stuff is out of my personal. I'm offering you an opportunity to get to a better spot. Offering you control of your peace of mind. Not while you're here, and unless you're in trouble, then I got you. But when you're not here, because again, doing it properly, making it bulletproof, and making sure you and your loved ones are protected when you're not here. Now, let's go into the problems with a poorly drafted trust. But first, a word from our sponsor, my water. And Twin, do me a favor, hit that like button, man, when you come in. All right. The problems with a poorly drafted trust. Ambiguity. Goodness, maybe I need some more water. Ambiguity. Undefined terms, which would be reasonable support, education expenses. They spark litigation. That is the point of what we're talking about being vague. Because when you put in something like reasonable support, just like I spoke about the reasonable officer standard. When I talked about the Castle Doctrine, when they used the word neat, the neat presentation, it is someone else's interpretation of what reasonable is, what neat is. If your trust is written and it puts reasonable support, what does that mean? Because for me, that might mean $1,500 a month. For someone else, that might mean $1,500 a week. For someone else, that might mean $15,000 a week. So it has to, again, address the issues that are set forth when you write it. Now, failure of formalities. Here's the easy. You ready? State trust codes. You're not using the proper codes. They don't have the proper codes in them in which offer the effect of a trust. Like California Probate Code, section 15200. It requires specific formalities, specificity. Miss them and the trust collapse. Everything you do has a process, and I've talked about this to nauseum. Specificity can destroy everything. Something simple as a state code can destroy your trust. And if it's not written by someone who knows what they're doing and how to protect it, you are just tossing money away. Now, the conflict of interest clause. If drafted too broadly, beneficiaries may allege breach of fiduciary duty. Again, specificity. Who gets what and how? This again goes right back to what I spoke about literally 5 years ago. Who, what, when, where, why, and how. all of that still applies not only to criminal law, not only to civil litigation in federal court, not only to the actual getting of documents, it applies to trust and asset protection. All of these things are things that can cause challenges to your trust. And these are the things that make it difficult to defend because you have someone that doesn't follow the guidelines and keep it simple. Now, the Supreme Court, Markham v. Allen, recognized federal courts' ability to adjudicate trust and estate disputes under certain diversity circumstances. Poor drafting can open federal jurisdiction. Remember, I told you, nobody wants to go to federal court. No one wants to. However, if it is not drafted properly, it can open up federal jurisdiction. And then it has to be tightened. Because someone going to federal court with your trust, if it is not if it's not fine-tuned, you are in trouble. Especially if you're the executor. Now, common legal challenges to trust. Now, I just gave you 4, the biggest problems. Now, actually instead of common, other legal challenges. The lack of capacity. Yes, there could be a lack of capacity in your trust. The standard testamentary capacity requires knowledge of property, natural heirs, and the effect of the trust. It's called the restatement of third party of property, or restatement of third of property. Simply means if there are multiple, and I'll give you a great example in my case. If there are multiple people or siblings and all that good stuff, everything must be tight. Because capacity requires knowledge of property. The only good thing about it, my natural heirs don't have knowledge of property. They just know something's there. They don't know where it is or how it is. They just know it's there. And at the end of the day, that actually kind of pushes them out of the ability to challenge it because they don't know where the property lies. And I actually did that on purpose because I don't trust none of them bastards. Anyway, love my kids. It's because somebody will clip this and be like, oh, he's saying he don't like. No, I don't like any of them. I love all my children though. Anyway, undue influence. One party exerting pressure on the settler. Courts often shift burden of proof if conditional relationship exists. This is one of those like Anna Nicole Smith. She was married to this young man. She technically, because she was his wife, was required or even had the ability, the standing, and capacity because of their marriage relationship to his assets. The children didn't think so because they were the natural heirs. The problem was she had a burden of proof of the relationship, which she showed and was awarded the money. Because, again, they could not assert or prove that she had undue influence to receive that money. Now, fraud or forgery. This is the most common. I'm going to say that one more time. This is the most common. Allegation that the trust was altered or fabricated. The reason why they use fabrication, if the trustee is not separated from the executor. I'm going to say that one more time. If the trustee is not separated from the executor, these are what they call a fabricated trust and can be challenged. Improper execution. This is also one of those that I've seen a lot in the last 90 days. Not meeting statutory requirements. And a lot of times you can actually see it whenever somebody sends it to you. You don't need, if you know what you're looking at or looking for, it doesn't take 30 hours and a ton of research. You can look at it and say, okay, something, yep, this is missing. And it's because, again, it is poorly written and it's not written by someone who can protect it. And a breach of fiduciary duty. This happens when somebody gets greedy for the most part, or your police officer. Now, I want you to understand this because I've said this before, but I want you to understand why I'm saying it. Trustee misconduct. Absolutely pause for dramatic effect because I want you to understand when I'm talking about a police officer, they have a fiduciary duty. Why? Because there's a trust in play and they signed to be the trustees. And a trustee's misconduct is a breach of fiduciary duty. This also happens when the trust is not written properly. You have things such as, again, in greed, self-dealing, and failure to account. These are things that are there, not high. Not these are not high challenges, but they are probable challenges to breach of fiduciary duty. But now, when I spoke about police, I'm talking about trustee misconduct, which creates the breach of fiduciary duty. So I'm gonna run through this pretty fast because I want you guys to understand something and get ready for the actual masterclass when I put these things up. Is the best defenses against your trust challenges. That's right, I said it because this is how I write your trust. No contest clause. Enforceable in most states, it's if properly worded. I got to say that one more time. And then I'm going to use an example of California. Enforceable in most states if properly worded. The verbiage must be done correctly. In California, again, probate code, section 21310, long as it is put in there properly, you are protected. Independent counsel or medical records prove capacity with comparative evidence. Now, again, these are things that prove the natural heirs. Because matter of fact, I want to say it's a couple of movies that we can actually recognize where you have these people that show up to long lost relatives and be like, oh, well, I'm the daughter of this billionaire. And they be like, oh, what the hell? Well, I'm the son of this billionaire. And they're like, well, their medical record show that they are a natural heir. And again, they're generally part of the trust automatically because they are a natural heir. And detail trust provisions, specificity, define discretionary standards with precision to avoid ambiguity. Good God, man. Trust protector. Be specific. And trust protector or independent trustee. Adding oversight reduces attack vectors. I have a trustee. I have somebody that does what they're supposed to do with it. But I also have a law firm that is attached to watch him. I have somebody watching the watcher, have somebody else watching the watcher that's watching the watcher. Because I don't trust nobody. Anyway, but again, it's making sure there are levels of the execution. And in the midst of that being done properly, you then have an opportunity to make sure, again, you control the protection that you're trying to build. Now, federal tax compliance. Ensure the trust doesn't trigger unintentional IRS audits. ERISA, ERISA, and federal tax code compliance is critical. This is where the trust gets in trouble. If it is not written properly, you want to make sure it is tax compliant. And again, Fort Valley State, Anyway, this is one of the reasons why someone must know what they're doing to incorporate and put this together where it's bulletproof. And arbitration and mediation clauses. Now, I'm not a fan of arbitration nor mediation. However, a lot of times you don't need the extra people getting into your business other than getting distribution the way you want it done. So some states allow binding arbitration clauses in trust, and that's Rachel v. Riaz, Texas Supreme Court. And yes, I'm going to use Texas because I love Texas. I'm here in Texas. That's what I do. I'm Texas. Texas, Longhorns, all that. But understand, it's putting it together and making sure that that clause not only is allowed, but it's also executable if necessary. Because again, you control that aspect of it, but making sure it's there. Because even give you an example, writing let's say a rule book, a guidebook for a business. 10 years ago, light work, just get it in there. Don't do this. You can do that. And then it's great. But then there's this thing called social media. What happened was there was a necessity clause that was incorporated. Why? Because you had a young lady at Chipotle, and she started not only showing what was going on at her Chipotle, she actually showed how things were made and what boxes and things of that nature were brought in while wearing a Chick-fil-A uniform. This now is a clause that is put into this same business contract that everybody signs, but now there's a social media section. Because not only if you're in uniform, you have to sign something that says that your likeness can be used. But also, you can't distribute anything in your uniform without prior authorization, because it then becomes grounds for immediate fire if it violates not only company policy, but a morality clause which allows people to get rid of you. The trust is affected the same way, because there are generally things that are not there in certain instances which now make it a necessity for it to be there simply because. Now, Clark v. Raymaker. SCOTUS rule inherited IRSs aren't protected in bankruptcy. Inherited IRS, goodness, man. IRAs aren't protected in bankruptcy, showing why asset protection trust must be carefully structured. Again, your IRA is not protected even if there's a bankruptcy, except through a trust. Why? Because the Supreme Court, the law of the land, stated in 2014 it wasn't. So again, understanding this, we spent this time dissecting the world of trust. Well, not really dissecting, but we dove into it. We dropped our toes in the water of it, because we understand now it's important and why it's important. And if there's one takeaway I want you to walk away with, is this: a trust is only as strong as the perception of the creation. The perception. A trust is only as strong as the precision of the creation. It has to be specific, and it has to be done properly with the proper verbiage. That is the key. Trusts aren't just about paperwork. They're about power, control, and protection. I'm going to say that one more time, because most of us don't think we have any of that. It's about power, control, and protection. Not necessarily for you, but for those that you are working 4. They are, if when they're written correctly, they are shields against creditors, courts, and chaos. Because just like I told you, I have family members that passed that did it correctly. They're able to grieve because they're not swamped in the chaos that the others who did not do it properly are now engulfed in. And when it's written improperly, they become open doors for litigation, they become open doors for fraud, and they become open doors for family wars. Understand that. The whole context is power, control, and protection. And you wield that. That's yours. And remember, the most common challenges: lack of capacity, undue influence, fraud, improper execution. All remember the defense: airtight drafting, medical documentation, no contest clause, trust protectors, independent trustees. Those are your weapons. Specificity, verbiage. I can't say this enough. And the Supreme Court has made it clear in decisions like Hodel v. Irvin, Clark v. Raymaker. Property and trust rights exist at the intersection of state power, federal oversight, and constitutional protection. That means you have to prepare on all 3 levels: state statutes, federal tax, and Irish law, it's ERISA, and constitutional guarantees. It must be written on 3 different levels in order for it to have effect and be able to do what it is that you're asking it to do. Or it is just a piece of paper. In many cases, this is an expensive piece of paper if it's not done correctly. Because not only is it waste of the money that you spent, but it doesn't protect anything that you had it set up to protect. So there's more expenses. Then there's tax liability. So again, let's say I actually had somebody tell me, I think yesterday it was $10,000. They spent $10,000 on the trust. And I cracked up laughing. I was like, okay, the assets are at least, $200,000-300,000. Well, the trust wasn't written properly, so they lost the $10,000. They were taxed on $500,000. So now the tax liability is at $250,000. So now their drop was $260,000. So it cost them, that $10,000 mistake cost them $250,000. For what? Because they did not have someone write it that can defend it, and nor was the trust specific or set up on all 3 levels as it's supposed to be. And my advice is simple. Don't hand your heirs a lawsuit. Hand them a fortress. Build your trust with foresight, precision, and professional guidance. This is how you secure your legacy. This is how you protect what you built. And this is how you make sure your story is told without interference. This is Supreme. This has been my 2 cents. Spend it how you like. And don't forget, bulletproof your estate. Thank you for joining. Don't forget, if you need to contact me, the email is in the description. As well, if you want to donate to make sure the channel keeps going and growing, it's in the description. As well, if you need a consultation with your boy, hit the consultation link, set up a 30-minute call, and we're going to keep it going. Supreme, I'm out, people.